Welcome back to another Explainer. Today, we're diving straight into a massive legal stress test of South Africa's brand new 1996 constitution. We're going to explore this fascinating and honestly kind of wild legal paradox that literally threatened to freeze the operations of an entire major city. It's a story about transition, vital legal scaffolding, and really, how a young democracy manages to keep the lights on while completely rebuilding its foundation from scratch. So, to set the stage for you, imagine this high-stakes scenario. What actually happens when a country's brand new, globally celebrated constitution directly contradicts its very own transitional laws? This wasn't just some abstract academic debate, you know? Back in 1997, this exact paradox created a full-blown crisis. We had a completely paralyzed city council in Greater Johannesburg. They were totally unable to lawfully pass their budget because the politicians were caught between two completely different sets of rules for how to vote. Okay, let's dive into this. On May 31st, 1997, the Greater Johannesburg Transitional Metropolitan Council held this absolutely crucial meeting to pass its budget for the upcoming financial year. And here's what happened. The budget won a simple majority of the votes, meaning over 50% of the members approved it. But it failed to hit a two-thirds majority. This split the room right down the middle, and not just politically, but legally. One side is claiming the budget was lawfully passed, while the other side is shouting that it's completely invalid. Bam, a massive legal deadlock over unauthorized finances. Section 1. A clash of laws. And this brilliantly illustrates the core problem. The politicians in that council chamber weren't just arguing over numbers. They were caught between two entirely valid, yet completely conflicting frameworks. Under the permanent 1996 Constitution, Section 160 clearly says a municipal budget is approved by a simple majority. Simple enough, right? But wait, under the Local Government Transition Act, we'll call it the LGTA for short, Section 16.5 explicitly requires a two-thirds majority. Imagine the cognitive dissonance facing the council. Which law governs a country in transition? The Permanent Constitution or the Transition Act? Let's look at Section 2, the procedural detour. Before we can actually solve that budget crisis, we have to take a brief but really fascinating detour into how a young democracy navigates brand new procedural hurdles. The urgency here was very real. An entire major city's finances hung in the balance. So, the burning question was, how do you get this paradox answered by the highest court as fast as possible? Can you just bypass the Supreme Court of Appeal and go straight to the Constitutional Court? Under the old rules, sure, maybe. But under the new 1996 Constitution, the exact paths for appealing constitutional matters hadn't been fully ironed out yet. Tracing the route of this appeal, it all started in the Witwatersrand High Court. High Court Judge Snyders initially hesitated to give a positive certificate for a direct appeal to the top court. And her concern was actually very practical. I mean, in a young democracy, every single litigant thinks their constitutional issue is the most important, right? She really wanted to avoid inundating the top court and delaying justice for everyone else. So she suggested it should go through the Supreme Court of Appeal first. But President Chaskalson of the Constitutional Court took a totally different view. He ruled that in purely constitutional matters with urgent, real-world stakes, bypassing the Supreme Court of Appeal is directly in the interests of justice. He essentially said, look, a direct appeal from the High Court to this court will often result in the saving of time and costs. And that was absolutely crucial here, because this contentious issue was threatening to derail city budgets all across the country. Moving on to Section 3, the transitional bridge. Now, what's really interesting about this slide is the concept of Schedule 6. With the procedural detour settled, the Constitutional Court had to find an elegant solution without breaking the brand new Constitution. Enter Schedule 6. The court defined this as a set of transitional arrangements. I want you to think of it like vital legal scaffolding. When you're pouring a brand new constitutional foundation for a country, you can't just demolish the old building overnight or the whole thing collapses. Schedule 6 was this essential scaffolding designed to keep the old local government systems running temporarily, just to prevent total chaos while the new system was being set up. So the Constitutional Court solution wasn't actually about deciding which law was better. It was all about exactly when each law applied. If we walk through the timeline, yes, the 1996 Constitution was enacted, but it explicitly protected the Transition Act for a very specific window. This scaffolding was set to automatically expire on April 30th, 1999. Justice Yacoub made this incredibly clear in his judgment. He observed that without this transitional bridge, existing local government laws and structures would be instantly invalidated the second the new constitution came into force. And because the new infrastructure just wasn't ready yet, this instant invalidation would, as he put it, likely result in sheer chaos. The scaffolding wasn't just some legal technicality, it was an absolute necessity for survival.
Now for Section 4, breaking the deadlock.
Well, lawyers being lawyers, there's of course a highly technical challenge to this scaffolding. The appellant came to the court with this very clever, or maybe tricky is a better word, argument. Schedule 6, Item 26.2 explicitly stated that the LGTA's two-thirds majority rule may not be repealed before 30 April 1999. The appellant argued, hey, this only prevents politicians in Parliament from formally repealing the law. They claimed it did not protect the law from being struck down and invalidated by judges for being unconstitutional against the new simple majority rule. So, the crucial point is how the court handled this logic. Justice Yakub firmly rejected it, calling it an inevitably absurd consequence. I mean, think about it. It makes absolutely zero sense for the framers of the Constitution to carefully protect a law from being repealed by politicians, only to intend for that exact same law to be instantly invalidated by the courts the very day the Constitution took effect. That would make the protective clause completely pointless. Ultimately, Justice Yakub perfectly harmonized the two laws. By reading the Constitution as a whole, he concluded they don't actually conflict at all because they are never active at the exact same time. The LGTA's two-thirds majority rule is the law of the land until April 30th, 1999. Meanwhile, the Constitution's simple majority rule basically slumbers, waiting in the wings, and only wakes up after that date. It's a completely seamless transition. Which brings us to our final part, Section 5, building a new democracy. Ultimately, we have to remember why these highly technical legal mechanisms matter so much. They literally dictated the survival of a developing government. The rules debated in this case determined whether cities could fund their essential services during a very fragile political transition. Now, the appellant had argued that the two-thirds rule violated democratic principles because it allowed a minority to block a budget. But the court clarified exactly why this Transition Act included deadlock-breaking mechanisms. For instance, allowing a provincial member of the Executive Council, an MEC, to step in and approve a budget if the city failed to do so. These tools exist precisely so a stubborn minority cannot hold a city to ransom and freeze its operations. The MEC has to act in good faith, and their actions are always subject to constitutional scrutiny. It's a beautifully pragmatic safety net for a young democracy. And that brings us to the end of today's explainer. The 1996 South African Constitution didn't just establish a shiny new ideal, it brilliantly engineered a time-delayed bridge to safely carry the country to that ideal without the whole thing collapsing along the way. So it leaves us with this really profound question to reflect on. How much scaffolding does a newly formed democracy actually need before it can stand entirely on its own? Thank you so much for joining me today, and I hope you walk away with a richer understanding of this remarkable legal balancing act.